Law Society. Thank you, Mary Ellen, and thank you for Thomas Linzey for being here. Thomas Linzey serves as Senior Counsel for the Center for Democratic and Environmental Rights, an organization committed to globally advancing environmental rights. He is the co-founder of the Community Environmental Legal Defense Fund and is widely recognized as the founder of the contemporary community rights movement, which has resulted in the adoption of several hundred municipal laws across the United States. He also sits on the board of advisors of the New Earth Foundation. Linzey is a cum laude graduate of Widener Law School and a 3-time recipient of the law school's Public Interest Law Award and has been awarded numerous other honors. Additionally, Linzey is the author of Be the Change, How to Get What You Want in Your Community, the author of On Community Civil Disobedience in the Name of Sustainability, and the co-author of We the People, Stories from the Community Rights Movement in the United States. He has served as a co-host on Democracy Matters, a public affairs radio show broadcast from KYRS in Spokane, Washington, and syndicated on 10 other stations. He was featured in Leonardo DiCaprio and Tree Media's film 11th Hour and We the People 2.0. He's assisted the Ecuadorian Constitutional Assembly in 2008 to adopt the world's first constitution recognizing the independently enforceable rights of ecosystems, and is a frequent lecturer at conferences across the country. His work has been featured in the New York Times, the LA Times, Mother Jones, and Nation magazine. He was named in 2007 as one of Forbes magazine's top 10 revolutionaries, and in 2018, Linzey was named as one of the top 400 environmentalists of the last 200 years. He is currently working on a new book, Modern American Democracy and Other Fairy Tales. Please welcome Thomas Linzey.
Great. Thanks, Liza. Yay, virtual. So I know we're all tired of looking at screens probably at this point. So I'm going to try to keep this as exciting as I possibly can and talk for about 20, 25, 30 minutes somewhere in there, and then leave the rest up for Q&A. And then whoever has the stomach to watch the presidential debate tonight, more power to you. So there'll be time for that. At the outset, I just wanted to thank Mary Ellen and Liza and Laura and all the folks that helped to make this happen. So what are we talking about tonight? Well, tonight we're going to talk about civil rights type protections for nature that jurisdictions, municipalities, countries, and courts are beginning to recognize human civil rights type protections for nature. And what does that mean? Well, we're used to human rights, right? We're used to First Amendment free speech rights. We're used to due process, equal protection rights, Con 1 and Con 2, learning about federal constitutional rights and to a lesser extent, state constitutional rights. What we're talking about here is that just as society recognizes the highest values within a society from a human perspective as rights, speaking our rights language for those values that we hold very highly, like freedom of religion and freedom of speech, that there's such universal agreement to those values that we speak about them not just in terms of values, but in terms of rights. And we actually codify them. Many are codified, of course, in the federal state constitutional structures, but we codify them so that they have protections against incursions or violations of those rights. So what we're talking about is basically elevating environmental protection to the highest level of protections under Western law. So shifting it from just a value of environmental protection is a good thing to actually environmental protection should be guaranteed as a right, a rights-based protection that accrues to nature. And that's the piece of what we're going to be talking about tonight. Not just a human right to a clean environment, which a lot of countries recognize, but a right of ecosystems and nature to a certain type of rights that recognize that violations of those rights or degradation of those rights or the natural environment is not allowed under the law. That's what we're talking about. So we wouldn't be talking about any of this. We wouldn't be talking about civil rights protections for rivers and civil rights protections for forests and mountains and lagoons and bays and oceans. Kind of bends our brains to talk about civil rights on behalf of anything other than Homo sapiens, humans themselves. But that's what we're talking about. We wouldn't be talking about these things if our existing system of environmental protection was working. So if our existing system of regulations, environmental regulations, permits, Clean Water Act, Clean Air Act, National Environmental Policy Act, Endangered Species Act, if those laws were actually working to protect the environment, we wouldn't be talking. I wouldn't be here tonight. You wouldn't be listening. We wouldn't be entertaining this topic about civil rights protections for nature. But the problem is that existing environmental law today isn't working. And you don't have to take my word for it. Just look out the window, whether we're talking about climate change or the fact that about 80% of the public now lives within 10 miles of a Superfund site, the extinction of plants and animals around the globe. No matter what metric we use, it doesn't take a lot of convincing for us to come to grapple with the fact that our environmental protection laws aren't working. Now, it's not like people wake up usually in the middle of a week and say, hey, the environmental protection system isn't working. Let's give civil rights to that river down the street. It doesn't work that way. And while people travel many paths to that point where they say a new system is necessary than the environmental protection system we have, a lot of environmental lawyers in my field, colleagues, peers, traveled the same kind of journey that I traveled, which was we tried to make the environmental laws work. So for 10 years, right out of law school, and I was one of the stupid ones that came out of law school, we created our own law firm 48 hours after graduating. That law firm was called the Community Environmental Legal Defense Fund. It was a nonprofit law firm. Don't do it. Thinking about it, don't do it. It's crazy. But in law school, we said to ourselves, well, the US has the best system of environmental law in the world. We have such a good system that we export our lawyers out to other countries to help them replicate these systems of environmental law and regulation. So the problem can't be the laws themselves, because the laws are fine. The problem is that we don't have enough people, lawyers, enforcing the laws. And it still floors me today, but the statistics are about the same today as they were when I was in law school, which was a long time ago, 25 years ago. And that is that there are only 200 full-time public interest environmental lawyers in the United States today. Only 200 full-time public interest environmental lawyers in the United States today. And so when I was in law school, we said to ourselves, well, the problem isn't the laws, the problem is there's not enough people enforcing the laws. And so we created a nonprofit law firm whose goal, whose mission was to provide free legal services to community-based environmental organizations. So these are groups that come together around a kitchen table sometimes in a rural community and are faced with a toxic waste incinerator, or a frack well that's coming in, or a frack wastewater injection well, or large-scale water withdrawals by Nestle Corporation or other companies that come in to take water. So you name the issue, we were involved in it in rural Pennsylvania. I went to law school at Widener Law School in Harrisburg, so the south central part of the state. We set up shop there. At one point, we had about 100 groups that were our clients. So these are rural, community, environmental organizations, as grassroots as it gets, who are trying to stop these unwanted projects from coming into their municipalities, their cities, towns, counties, boroughs, you name it. And our practice for 10 years, so we're talking 1995, most of you weren't born then, but 1995 to 2002, 2003, somewhere in that time range, we tried to make existing law work. And the job of environmental lawyers then was exactly the same as environmental lawyers now, which is that the company that was putting one of these facilities in, frack well, hog factory farm, you name it, would apply to the state for a permit, to get a permit to put the facility in. That's how environmental law operates today, is through this permit issuance system. And the state would issue the permit, the community group would be upset, they would hire a lawyer, they would retain us, we would come in, represent them. And our job was to find gaps, omissions, and deficiencies. Same thing today as back then, but gaps, deficiencies, and omissions in the permit application that had been submitted by the corporation for the facility. Our argument in front of a judge was simply, Your Honor, something's missing from this permit application. State agency never should have issued the permit. We want you to overturn the permit that was issued so that the facility doesn't come in or site in the community. And most of the time it turned on a signature on a page within the permit application. The president of the corporation hadn't signed it, but the regulations required him to sign it. A bonding amount was not enough. The corporation would post $20,000, should have been $40,000. Might have been a water study that was 10 years old. It was stale. It should have been updated. So we would be arguing to the judge, which maybe some of you will eventually be doing in the near future, but arguing to a judge, Your Honor, under section 24, little c, little d, little I, little Roman numeral 2, little I, little c, little 2, little d, little I, little e, little c, that there's a signature missing from page 64. And because of that, the permit never should have issued from the state agency, and therefore you need to overturn the permit. That was the basis of our life. And environmental lawyers, that's what they do. They sit in a room, permit application on one side, regulations on the other, and then they try to find gaps, omissions, or deficiencies in the permit application so that the permit doesn't issue. And for those 10 years, we had a great win-loss record. It was like 124-3 or something over this period of time, because we would win the first round. First round, we would go in, we would make the arguments to the judge. Corporations, a lot of the big companies, we were up against Waste Management, Chemical Waste Management, Monsanto Corporation, Smithfield Foods, Hatfield Foods, big boys. These are the biggies that we were involved with. They don't really care. A lot of it is slapdash when they put a permit application in. Most of that is, reason for that is because almost 90% of all permits never get appealed in the United States. And they never get appealed because the communities can't afford to appeal them. Costs real money. It's you're rubbing nickels and dimes together in most places just to get photocopies or gas, let alone appear in court and make these arguments. And so we would almost always win the first round. And what would happen next after the judge had thrown the permit out is we'd all go back to somebody's house with the community group, and we would have a victory party. And we would drink some beer, and we'd have wine, we'd have snacks. People would pat themselves on the back and say, "This is great. This was a problem. We're not going to get the toxic waste incinerator. We're not going to get the factory farm. We're not going to get whatever the hell we were fighting at the time." And we found a lawyer who could speak intelligently, somewhat intelligently. We found a judge that agreed with them. That's great. We're not going to get the facility. Well, what would happen 30 days later? Well, the corporation would come back. And this time they come back with a new and improved permit application. And they would take our work, the gaps, omissions, and deficiencies that we found within the permit regulatory, the application that had been filed by the corporation, and they would fill them in. It got to a point where at some of these hearings, after we were done and we had won the first round of these permit appeals, that the lawyers for the corporation would come over and thank us for finding the gaps, omissions, and deficiencies, because then they could bill the corporation more hours to actually fill in the permit application to resubmit it to the agency. And so I'm shortening all this for purpose of the talk. Some of these lasted 7 years, round after round after round after round, all about the permit application and whether the permit application was administratively complete. If you practice environmental law, you will eventually hear the phrase administratively complete at least 17,000 times a year. The permit is administratively complete, it issues. And so the problem was that we were eventually losing. We weren't stopping anything. Toxic waste incinerators were coming in, factory farms, it didn't matter. We would win the first round or first couple rounds. The corporation would eventually come back. The community group would come back to us and they'd say, "Mr. Linzey, we need you to do that jujitsu again that you did the first time around to get this permit out. We don't want the facility." And frustratingly, we would have to look back at them and we would say, "We're sorry, there's nothing we can do at this point because the permit application is administratively complete, has everything in it. We don't have any levers anymore from the regulations that we can use to actually get rid of this permit." And so we came to a realization back in 2002 that environmental law really didn't have much to do with protecting the environment. It still sounds strange to say it, kind of bends our brains a little bit, but it really is true. It's about shaving the roughest edges off of some of these projects. But it's about legalizing the harms that come from them. We don't really think about permits that way. We think about permits as regulating the facility to try to protect health, safety, and welfare in the natural environment. But in some ways, what the state is doing, government is doing, is legalizing a harm by giving the corporation the permit, allowing them to cause harm through this particular project. It's almost like, looking through the looking glass or on the other side about how the system actually functions. And there's this little thing in the law that you'll trip over if folks practice environmental law called the permit shield defense, which is you can't sue the corporation for anything it's doing as long as it's complying with the conditions of the permit. So the permit's like a shield. The permit goes out, it's like a shield. It legalizes the harms that flow from operating in compliance with the permit. That's nuts, but that's how the system works. And so somebody back then, 2000, 2002, said something to me, a couple things that I wasn't smart enough to understand at the point, but eventually got smart enough to understand. And one of the things was we thought we were costing the corporations money. We thought if we were filing the permit appeal, the corporation had to hire a law firm, you know, $500, $700 an hour now, $1,000 an hour. For some of my peers in the environmental legal field, you get hired out by some of these big companies. Good money, it's you know, good stuff. That we at least thought we were costing them money. But it turns out that the monies that the corporation spent on defending the permit is tax deductible. It's tax deductible as a reasonable and necessary business expense under the IRS code. So on one side, you have the community groups who are trying to put two dimes together to do something. That's not tax deductible to them. But for the corporation coming in, they can write off the cost of the lawyers that are involved in this permit, you know, defending the permit issuance there. And so that told us that something was wrong structurally. And then this person said something else. Her name was Jane Ann Morris out of Wisconsin. She's a corporate historian. Unfortunately, she passed away a year ago. But she said to us also, she said the only thing that environmental regulations regulate are environmentalists. The only thing that environmental regulations regulate are environmentalists. Because we don't write the regulations. I used to work in the Harrisburg Capitol for the state of Pennsylvania, the legislature. I saw the agribusiness corporations write bills and hand them to the chair of the committees. And then they go through. And on the regulatory system, corporations writing the regulations for the agencies because our folks don't have time to do it. There's like 2 paid lobbyists for environmental groups in Pennsylvania. There's like 900 for corporations. I mean, who do we think is writing the regulations? But the problem is the corporations write the regulations. That's the script. And then environmental activism over the past 40 years has been following that script. And which puts us on the defense when the corporation comes in to put a project in. If you're Monsanto Corporation and you're writing the regulations, why in the world would you give the community any power at all to say no to the project you're trying to put in? It's nuts. But that's what environmental law has been for the past 40 years. The two things we talk about sometimes loosely when we're kind of joking around is the environmental system is a hamster wheel. Number one, it runs community groups until they pass out because, you know, they hire the lawyer, they become a fundraiser for the lawyer, they fight these permit issuances, and eventually they burn out. And the other thing is, I mean, anybody's been to a fairground, you know, the county fair. There's a game called whack-a-mole, you know, and you pop the mole pops up, you pop it on the head, another one pops up. Pretty soon there's so many popping up you can't keep them down. That's environmental law in a nutshell. Because as we were busy trying to stop one permit, 3 other projects would come up. And then stopping another 5 other projects would come up. We had one community that was faced with 4 toxic waste incinerators in an African-American community on the eastern side of the state. So all to say, to make a long story a little bit longer, which is that we began to re-examine ourselves. We began to find ourselves. And we decided that all we were doing was helping corporations build better permit applications. That's all we were doing. We're helping them enforce their own regulations, which is nice. I mean, they write their own regulations. We spend a lot of time helping them comply with their own regulations that they wrote. They say insanity, the definition of insanity is doing the same thing over and over again and hoping for a different result the next time. Well, we were definitely in that cycle of trying to make things work. Again, this is what environmental lawyers do. This is what environmental law pretty much is today. So what did we do? Well, we decided to stop. We weren't going to do it anymore. And so we quit. We quit doing the regulatory stuff. We quit doing the permit appeal stuff. And we started asking ourselves some really tough questions about what environmental law actually is. And how, in a deeper sense, the Western system of law, we're all under a European system of law in the United States. Comes over from England, common law. You know, I don't think they teach us in law school really, except a little bit. But that we have this Western system of law that kind of got transplanted into the colonies. We adopted it through the US constitutional system. And that Western system of law, make no mistake about it, treats nature as a dead thing, inanimate object, that our job is to exploit those resources, because we don't even call it nature, we call it natural resources. And we say our job for economy, to grow the economy and lives and prosperity and happiness, we have to exploit those natural resources. The best we can do is regulate the rate at which we exploit them. That's where the regulatory system kind of comes from. But this Western system of law sees nature as dead. It's dead. It's inanimate. It's to be used. And yes, we should regulate our use of it. But it is a dead, inanimate object. Indigenous communities, tribal communities, original peoples, First Nations, whatever the name we choose to give those indigenous communities, have a much different view of nature. Nature is living. It's animated. A bunch of our clients are tribes, like the Ponca Nation in Oklahoma, who recognized rights of ecosystems a little while ago in their tribal, constitutional and tribal law context. We're going to talk about that in a couple minutes. The Ponca people talk about speaking for those without voices, i.e. animals and ecosystems and rivers and nature. The White Earth Nation, also a client of ours, the Chippewa people in Minnesota, they talk about the flying people and the swimming people and the singing people. They talk about nature as alive, as animated, and that humans are just a part of that. And it always sounds kind of hippy-dippy to say this sometimes, but they see themselves as an integral part of those ecosystems, that they're just a player. They're a bit player. There's all kinds of other players, and their job is to speak and work for those other players, those other actors. Nature is an animated, living thing. The Yurok people in Northern California, we recently recognized that the Klamath River has rights, believe it or not. Talk about the Klamath River as a living being or a relative. Talk about nature and ecosystems as rivers as relatives. Contrast that to a Western system of law. Sir Francis Bacon is sometimes quoted as saying, he's an English philosopher, he said, our job of humanity, from a Western perspective, is to torture nature on a rack to extract her secrets. That's Sir Francis Bacon, well-known philosopher. Torture nature on a rack to extract her secrets. I don't think the disjunction happens any more than that. The disjunction between Earth as a living, animated system versus nature as a dead, inanimate system, that those two just can't be reconciled. The problem is under our Western system of law, because nature is a thing. Nature is not a person, nature is a thing, this dead kind of inanimate thing, that it gets caught up in property rights because nature is property under the Western system of law. If you have a deed for a 10-acre piece of land, generally that deed carries with it the right to destroy that 10-acre piece of land because through the deed. It's part of your bundle of rights, the right to destroy property 101, property 201, property 301. Doesn't matter how many 01s you add to the end. Part of the bundle of rights is the right to destroy. So what that means is that the more land, the more ecosystems you own, the wealthier you are, the more you can destroy legally under the law. That's how the law is set up. And because of that, the US Constitution protects property rights very strongly. And because of that, and because nature is property, that when you attempt to interfere or protect nature to a high extreme or a high level, you run right into constitutional safeguards that prevent you from doing so. It's like the regulatory taking stuff that they teach you in law school. When regulations go too far and they take too much value of the land for the property owner, they become unconstitutional. They cross that line into unconstitutionality. That's where our natural environmental protection stuff is caught. Because nature is property, you can't do much about it that interferes with those property rights that are constitutionally protected. So a lot of people at this point say, so what, right? We're under a Western system of law. I'm not Chippewa. I don't live on a reservation. This is just a system we have to deal with, and we have to make it the best that we can. You know, some people say that. Well, we didn't. And we started looking around for stuff that talked a different language. And what we found was back in 1972, a law professor named Christopher Stone, who teaches at the University of Southern California, wrote a law review article called Should Trees Have Standing? And people are probably familiar with standing concept, but you have to be physically injured to actually get into the courthouse. If you can't show physical injury or somehow that you're physically affected as a person, you can't get into the courthouse. Christopher Stone, law professor who wrote this piece, talked about nature having standing. That when something came in to threaten nature, ecosystems, a mountain, a river, lagoon, bay, ocean, that the natural system itself should have standing, should be able to be a plaintiff in a court, which is not the situation today. But that harm inflicted the viewpoint of the court should be, is harm inflicted to the natural system, not to the person using it, but to the natural system itself. And there was kind of a perfect storm that happened in 1972 when that law review article came out, because there was a case in front of the US Supreme Court called Sierra Club versus Morton. The name of the case isn't important, but the Walt Disney Company wanted to build a ski resort in the Sierra Nevada mountains. So folks are familiar with the area, it's on the border with Nevada. You travel directly east from San Francisco. You run into the Sequoia National Forest, which was not the Sequoia National Forest back in 1972. Suffice it to say, Walt Disney wanted to put in a facility that would handle 1.7 million annual visitors to the ski resort. It would have been bigger than Disneyland. I think that's all we have to say. Bigger than Disneyland in this place. It's now the Sequoia National Forest. Sierra Club sued to stop the project. They sued the Secretary of the Interior to stop a permit from being issued. The courts dismissed the Sierra Club's case because of lack of standing. They held that Sierra Club members didn't have standing because they weren't affected by the development. Nobody lived there. Nobody had property there. Nobody was physically harmed or affected by it. And so the courts dismissed the Sierra Club on the basis of standing. Went up to the US Supreme Court. And at the US Supreme Court level, the Supreme Court also dismissed the case on lack of standing for the Sierra Club. There was a dissenting opinion filed by a guy named Justice William O. Douglas, probably one of the most progressive Supreme Court justices that we will ever have on the Supreme Court. And he wrote a dissenting opinion in which he borrowed Christopher Stone's piece about whether trees should have standing and wrote it directly into his opinion. His argument in the dissent was that the case shouldn't be labeled Sierra Club versus Morton, but Mineral King versus Morton. Mineral King Valley was the valley in which the Disney company was trying to put this development, but that the natural, or in this case, the ecosystem itself should be the plaintiff, not individual people. And the measure of standing was whether the natural system was going to be injured or harmed, not the people that use that natural system or ecosystem or natural feature. And so Sierra Club versus Morton, that dissent came out from the US Supreme Court. Not much happened. People read it, they enjoyed it as an academic exercise, but not much happened. And that thread got picked up finally in 2006. So 40 years, almost 40 years after that opinion was issued from the US Supreme Court, one of our clients, a little community called Tamaqua Borough, which is northwest of Philadelphia. It's a small community, about 7,000 people. They were targeted with a dump plan from the governors of Pennsylvania and Delaware, who were deepening the Delaware River to bring more traffic into the Delaware River, commercial traffic. To do that, you had to dig out the riverbed. And the riverbed was full of PCB-laden dredge, so polychlorinated biphenyls, nasty stuff. PCBs were all through the dredge in the bottom of the Delaware River. The governor said, hey, we got an idea, let's dump it in Tamaqua Borough. Tamaqua Borough, big mining area, has open mine pits still throughout the region. The idea was to truck it into Tamaqua Borough and dump it into the old mine pits. That was what the brain surgeons at the regulatory agencies gave us to get rid of the PCB-laden dredge. People in the community in Tamaqua Borough said, no, I don't think so. We don't want to be a toilet for Philadelphia. If you want to dispose of that stuff, stick it in the backyards of the McMansions in suburban Philadelphia. That would be fine, thank you, but don't bring it here. And they talked to us about banning the dumping of dredge within the community. And so we worked with them to draft an ordinance that bans the dredge from coming in. But then the fishermen, mostly trout fishermen in the area, came to us and said, well, this is great, but this ban is good. But if the stuff actually comes in, it's going to have an impact on the waterways within Tamaqua, where we fish. and we recreate, we enjoy these riverways. Places like the Little Schuylkill River, which is supplies Philadelphia with drinking water. So big, big deal. Panther and Wabash Creeks, also fishable within the borough of Tamaqua. And we had been talking with them about this U.S. Supreme Court opinion, the dissenting opinion in Sierra Club versus Morton, and this concept about nature having rights. And they asked us to draft an ordinance, a local law, that recognized that the river and the creeks had the right to exist, flourish, and naturally evolve. So again, rights to exist, to flourish, naturally evolve as waterways, as rivers and creeks within the community. To our amazement, I think, we drafted the ordinance, handed it off to the Borough Council, and they adopted it. It became the first law in the world to recognize rights of ecosystems in the globe. First one, the small little communities of non-people. And the law contained 3 elements, which have become, like, in the words of lawyers, irreducible minima. I love using that phrase, irreducible minima. They had 3 elements. One was rights. Nature has no rights. In Tamaqua Borough, nature has rights to exist, flourish, naturally evolve. The terms became different over the next 10 years, but that's where we started. Had a provision allowing residents to step into the shoes of the river to sue on its behalf against things that would violate those rights of the river. And finally, a remedy section about restoration, that whoever violated the rights was legally obligated to restore the waterways back to its pre-damaged state. So that was Tamaqua. The law passed. Dredging plan got killed in response to opposition from the community, not just the laws, but opposition from the community and everything else. And we thought to ourselves, wow, this is an interesting concept. And about that time, we got a phone call from Ecuador. And turns out in Ecuador, they were beginning to draft a new national constitution for the country of Ecuador. They had elected the delegates were meeting, and lo and behold, they learned about Tamaqua. Talk about a small world. These are Ecuadorian constitutional delegates gathered to write a new constitution who had read about Tamaqua and the rights of nature law that the Tamaqua Borough had passed. And they called us to ask us if we were willing to come down to Ecuador to help write the new national constitution to shift Ecuador from being a property-based environmental protection system, which is what we have now, to a rights-based environmental protection system. And we said, yeah, we don't have anything else to do. Let's go down to Quito and meet with some folks and talk to them about what happened in Tamaqua and help them draft language. And they drafted language that eventually made it into the Ecuadorian constitution. The voters of Ecuador voted on it, overwhelmingly ratified. Fascinating stuff. First country in the world to do this. And then we started to watch as lawsuits began to be filed. There's been 60 enforcement cases now in Ecuador around the rights of nature stuff. The first case was brought by a river as a plaintiff. I know this bends our brains even more, but the case name was Vilcabamba River versus Province of Loja. Specifics aren't that important, but 2 people, neighbors of the river, stepped into the shoes of the river to sue a local government who was polluting the river. And for the first time in history, well, at least Western history, a judge ruled in favor of the river and issued an injunction to stop the local government from polluting the river. So big news, big times kind of stuff. And again, 60-some cases in Ecuador that have begun to apply rights of nature. And in fact, the Constitutional Court recently accepted several new cases to further define what those constitutional rights mean in terms of what violates them in the country of Ecuador. So what happened next? And I'm gonna finish out with three things here, and then we're gonna talk about stuff. So in 2010, the Ecuadorian work went around the world. I mean, we were fielding calls from CNN, MSNBC, nightly news, the coverage, newspapers, everybody was excited. In 2010, we got a call from the city of Pittsburgh, where there was a plan for the oil and gas companies to frack under Catholic cemeteries within the center of the city of Pittsburgh. So fracking under grandma kind of thing in the Catholic cemetery. Got a lot of people upset in the city of Pittsburgh. They came to us and they said, hey, we want to ban fracking within the city. We said, sure, we'll help you do that. And then they said, but we've also read about Ecuador and Tamaqua and this other stuff happening. We want to protect the 3 rivers within the city, the Ohio, the Allegheny, and the Monongahela. And would you draft something like that? And we said, sure. And so we drafted it. We worked with them on the draft. And amazingly, the city council unanimously approved not only the ban on fracking, but rights of rivers within the city of Pittsburgh. Still law today in the city of Pittsburgh. Other things folks may have heard about: the Lake Erie Bill of Rights in the city of Toledo. 62% of the public voted to adopt a Bill of Rights for Lake Erie. Contains some of the same standards: exist, flourish, thrive, regenerate, be restored, expansion of some of those constitutional type rights for ecosystems. And then something, I know I've used the word amazing a lot, but this is really amazing, which is that up till now, it had been laws passed by people, passed by legislatures, passed by constitutional writers. But then courts and judges started to step outside of that legislation and rule on behalf of international courts that nature had rights. So in 2016, the Colombian Constitutional Court, without any laws whatsoever, held that the Rio Trato River in Colombia had rights, that it was a subject of rights. And when asked, they did in their opinion, when asked how, they said, well, what happened in Ecuador and some of these other places really evidences a new norm of international environmental protection. They didn't need a law. They just stepped out and said, this is the law. And we find it's a new system, new emerging norm of international environmental law. And then in 2017, an Indian court ruled that the Ganges River was a legal person subject to rights, that had rights. So that was interesting. And then in 2018, the Colombian Supreme Court issued a new ruling about the Amazon and the Amazon River Basin, holding that they had rights and that those rights could not be violated by activities in the basin or along the river that would violate those rights. In 2019, the High Court of Bangladesh, legal rights for all rivers in the country in Bangladesh. In New Zealand, there's an agreement with the indigenous people in New Zealand to recognize a river and a forest as having rights of their own. And then in Uganda, apart from the court stuff, just last year, they passed a National Environmental Act which recognized rights for all ecosystems in Bangladesh. So again, incredible stuff. And then coming back around to the final piece, which is, we talked about tribal nations in the beginning taking up this work. In 2015, the Ho-Chunk tribe in Wisconsin became the first tribe to vote on a rights of nature provision within their constitutional framework. Just like, states have constitutions, tribes have constitutions. And tribes can change those constitutions through member votes or through tribal council. The Ponca in Oklahoma also passed a rights of nature law. The Ojibwe or the Chippewa, the White Earth Nation in Minnesota, passed a rights of nature law to protect wild rice, their cultural staple. The Menominee in Wisconsin, Menominee Nation, passed a resolution to protect the Menominee River. The Yurok tribe in Northern California recognized that the Klamath River has rights, basically trying to restore salmon runs for the river itself. The Nez Perce in my neck of the woods, I'm in Spokane, Washington, on the eastern side of the state. The Nez Perce are about 30 miles away in Idaho, passed a resolution recognizing rights of the Snake River. That happened 3 weeks ago in terms of recent developments. And so just to finish up here with some kind of recent stuff, but it used to be 25 years ago, if you had talked about rights of nature, you get laughed off the stage. And in fact, we did. So I did a speaking tour of law schools way back in 2005 with a South African lawyer that was working on rights of nature. We got about 10 minutes into presentations and the environmental professors, law professors, would walk out of the room because it was nuts. It's like the lunatic fringe. But today it's much different. It's almost like inching its way into this mainstream thought process. 3 law schools, the University of Florida in Gainesville, Tulane Law School in New Orleans, Vermont Law School up in South Royalton, Vermont, have now held conferences that we've co-hosted with the law schools on rights of nature. And in fact, Professor Oliver Houck from Tulane, who is one of the authors of the Federal Clean Water Act, has now come out and said, this is the next evolution of environmental law that has to take place. That the current environmental law has deficiencies and limitations. We need to actually move beyond it to embrace this stuff. And again, use of the word amazing. Amazingly, back in 2016, the Democratic National Committee, the DNC, Democratic National Party in the United States, put a rights of nature plank into their national platform to recognize and support indigenous communities' passage of rights of nature laws. It's actually in the platform. Folks tried again this year in 2020, but it didn't make it. But in 2016, it actually was in the Democratic National Committee platform. The Florida Democratic Party, Florida of all places, placed a rights of nature plank into their state platform and are now supporting some of the stuff that's happening in Florida. I happen to think, and I'll end on this note, the most important environmental ballot initiative this year that's appearing on the ballot is in Orange County, Florida, where they're attempting to recognize rights for all waterways within the county of Orange. And if folks don't know Florida that well, think Orlando, that's Orange County. 1.4 million people would become the biggest jurisdiction municipality in the United States to adopt a rights of nature law. And they didn't do it because they woke up on a Tuesday and said, hey, let's do something crazy. Let's recognize rights of rivers. They did it because even before COVID, people were wearing not gas masks, regular masks on the beach because of the cyanobacteria, the red tide. They were using backhoes to scoop up dead sea life off the beach. So manatees and dolphins, they were carrying them off the beach with backhoes and backloaders. Biscayne Bay, southeastern part of Florida, just a week and a half ago, went to 0 dissolved oxygen levels. And you don't have to be a scientist to know that that's bad. That's 0, you can't sustain life with 0% oxygen levels. The nutrient pollution, everything had kind of overcome Biscayne Bay. I think it's very exciting stuff that's happening in Florida right now. There's about 13 counties that are thinking about doing the same. It's kind of a hot spot for this rights of nature stuff right now. So anyway,